Good evening and welcome to Blueprint Explosive Exclusive. I'm Madhavdas G. After decades of legal and historical contest, the Madhya Pradesh High Court has delivered a landmark ruling on the Bhojshala Kamal Mola Mosque dispute. The Indore bench has recognized the Bhojshala complex as a temple dedicated to goddess Vagdevi or Saraswati, observing that Hindu worship at the site has continued over time and was never extinguished. The court has also cited historical records and literary evidence linking Bhojshala to Raja Bhoj and its identity as a center of Sanskrit learning. With this ruling, the court has effectively overturned earlier restrictions and reshaped the religious status of the disputed site. Now, the High Court has declared Bhojshala as a temple, and these are the major takeaways from what has been stated by the bench. They've called Bhojshala complex a temple. They further called it Goddess Saraswati's temple. They further added that Hindus can perform puja in this complex. Namaz is no longer permitted in the complex, is what has been stated by the court. ASI's 2003 ruling now stands ineffective. The sixth takeaway is that Muslims can seek alternate land parcel in which to offer worship. They've also said that Bhojshala to remain under ASI's purview. Now, the ASI report was submitted in the High Court, following which both sides made their submissions. Let's tell you what the ASI found in their scientific study, which was mentioned in their report submitted to the High Court. What ASI specifically suggested is 1. The first finding is a painting of a Trishul. They had further found a mutilated sculpture of Vishnu and temple remains that were found there. Finding number 3, existing structure built on a pre-existing structure. Finding 4, superstructure of stone was modified and converted to a mosque. The fifth finding, images carved on previous structure were chopped off for reuse in the present structure. Finding 6, art and architecture on pillars suggest that they were part of temples' images of deities mutilated for reuse. Finding 7, images include Brahma, Ganesha, Narasimha, Bhairava, etc. Finding number 8, inscriptions start with Om Namah Shivaya. Finding number 9, the existing structure was made from parts of earlier temples. Finding 10, many Sanskrit inscriptions damaged and reused. Now, reacting to the Bhojshala verdict, Asudin Owaisi of the AIM has said that he hopes the Supreme Court will overturn the order. Owaisi also claimed that the ruling bears quote-unquote glaring similarities to Babri Masjid judgment. Here's a reaction from Dhar's Shehar Qazi, Wakar Sadiq, followed by BJP MLA रामेश्वर शर्मा.
हाई कोर्ट के फैसले की समीक्षा करेंगे. हमारे खिलाफ जो फैसला हुआ आर्गुमेंट के खिलाफ, तो यकीनन हम लोग सुप्रीम कोर्ट जाएंगे. सुप्रीम कोर्ट में प्रथम वक्त में ही जाके चुनौती देंगे और मुझको लगता है कि सारे आर्गुमेंट के बाद हम न्यायालय का सम्मान करते हैं, लेकिन ये जो फैसला आया है इसके खिलाफ हम सुप्रीम कोर्ट में अपील करेंगे.
जहाँ जहाँ हिंदुओं के स्मृति चिन्ह हैं, जहाँ जहाँ हिंदुओं के मंदिर हैं, जिन मंदिरों को औरंगजेब ने, अकबर ने, बाबर ने, हुमायूं ने, गजनवी ने, इन लुटेरों ने आकर तोड़ा है, इन मंदिरों को वो हिंदुओं को फिर से वापस करके दोस्ती का हाथ बढ़ाएंगे.
Now, reacting to this verdict, the counsel for the Hindu side, Vishnu Shankar Jain, has called it a historic judicial recognition of their claim over Bhojshala, while petitioners are also responding to the implications of the ruling on ground. Listen in.
भोजशाला के केस में ऑनरेबल इंदौर हाई कोर्ट का बहुत ही ऐतिहासिक फैसला आया है, जिसमें ऑनरेबल इंदौर हाई कोर्ट ने जो एएसआई का 7 अप्रैल 2003 का ऑर्डर है उसको पार्शियली क्वैश किया है और हिंदू समाज के लोगों को वहां पे पूजा पाठ का अधिकार दिया है. कोर्ट ने भोजशाला कॉम्प्लेक्स को राजा भोज का माना है, एक सरस्वती स्कूल माना है लर्निंग का.
हमने अपनी याचिका में इस बात की मांग करी हुई है कि जो लंदन की जो मूर्ति है जो म्यूजियम में रखी है माता वागदेवी की भोजशाला की, उसको वहां पे ला करके गर्भगृह में स्थापित किया जाए. तो ये प्रतीकात्मक रूप से अभी मूर्ति है, लेकिन जब फैसला आ जाएगा, अभी फैसला आने वाला है, हमारे पक्ष में आएगा फैसला, हमको पूरा विश्वास है.
Now, speaking to Times Now, the DIG of that area has explained how the police and administration is in constant contact with both parties in this particular case and have urged them to respect the decision of the High Court. He's also explained the multiple layers of security deployed at the spot and that security deployment won't be reduced for now. Let's go across to Shivam, who's joined us, who's actually got us that particular interview. Shivam, now, what exactly has the DIG told you? And take us to that particular area. Are there any devotees there who you can speak to as well?
Well, Mother, for now, the police authorities have, removed dispersed the authorities. They have been chanting the slogans here for like almost 2 hours now. But again, as this BNS 160 is currently in place. More than 5 people are not allowed here. This is the exact spot. You can see here also multiple layers of barricading. The police officials are also sitting here. The RAF officials are also sitting here. And this is just one layer of barricading. We are one layer inside. Then there is one layer outside as well of the same barricading. This entire area of almost a kilometer has been barricaded through all the sides, because again on the behind as well there is a residential area which connects it to the disputed complex, which has now been announced officially, being made as the temple by the two-judge bench in the Madhya Pradesh High Court. On the opposite side here, just for a few minutes from now, there were people chanting the slogans. They were doing all the celebrations. They were playing with colors, but for now the security officials have removed them, and this is what the DIG also said.
In fact, we're going to continue to report from Dhar in Madhya Pradesh, but let's listen in to what the DIG of police told us a short while earlier.
की बात हो गई थी और पर्याप्त संसाधन और बल हमको उपलब्ध कराया गया था। इस पूरे पॉइंट को देखते हुए, कोर्ट के निर्णय को देखते हुए हम लोगों ने काफ़ी 5-6 लेयर में व्यवस्था लगाई थी। भोजशाला के बाहर की व्यवस्था, अंदर की व्यवस्था। वी हैव RAF, वी हैव QRF, वी हैव STF, वी हैव वज्रवाहन, वी हैव वरुण वाहन। तो हम लोग ऑल अराउंड सुरक्षा को सुदृढ़ करने के लिए एक पुख्ता इंतजाम किए थे। एट द सेम टाइम हम लोगों ने जो इंटेलिजेंस सिस्टम हमारा है उसको काफ़ी स्ट्रॉन्ग किया था। सोशल मीडिया पे हमारी पैनी निगाह थी।
Let's take this across to our guest now. Joining us at the moment is Anurag Naidu, political analyst. We also have with us Subhrashtra, who's founder of The Churn. Joining us also Syed Asad Abbas, political analyst. Let me start with you first. Subhrashtra, very, very significant judgment coming in the High Court, but you have reactions coming in. For instance, Asaduddin Owaisi says that there are glaring similarities between what has happened in Dhar and what has happened in Ayodhya.
Yes, I think he's absolutely right, and we should acknowledge the fact that at least somebody from the Muslim community at large is acknowledging that a similar kind of cultural appropriation happened, and therefore I stand with Mr. Owaisi in sentiment. The thing is,
no, but Owaisi is hoping that Supreme Court will undo this. This is also part of his statement.
No, he can hope whatever he wants to hope of. I'm just talking purely from the analytical point of view. That in our past, we have had instances of temples being converted to mosques, architecture from the temples, sculptures from the temples, pillars, etc., being used to prop up a mosque and say this is our place of worship. And I think it's a part of a historical story, and one shouldn't dispute that. The problem is today, there are two communities at war over this. Do we have the honesty from one side to say that yes, in the past we've had certain instances where we did convert temples into mosques, and then we can perhaps move forward in a different direction. But till that honesty comes, until there is this whole assertion of supremacy of yahi tha, hamesha se tha, yahi rahega, then people are going to dig into past, and I think this is a natural corollary of that. If one were to look at the cultural significance of the goddess Vagdevi temple, Vagdevi is not just the goddess Saraswati in her sattvic form. It is also a tantric kind of a temple. There have been associations of this place being a place of imparting learning as well. So there are huge cultural cultural sentiments attached to this entire site. And I think every community has a right to say and assert that this is what
Okay, let's get a response from Syed Asad Abbas. Syed Asad Abbas, the High Court ruling at least has not gone in favor. The Shahar Qazi, they're saying that he's going to appeal the Supreme Court. But prima facie, they appear to have gone by what the ASI report has found. And the ASI report has found a lot of evidence, as per that particular report, that there was indeed a temple there.
Madhav Sahab, firstly, let us understand that the 1991 Places of Worship Act is still very much in existence. The fact of the matter, we need to understand the High Court coming in with such a verdict is quite surprising for me. Because let us understand, from 1947 onwards, the character of the place remains the same. So therefore, now this is in direct contention with the 91 Places of Worship Act. So this is something I'd really like to know from the Supreme Court of a country. Also, as a matter of fact, the same in the year 2002, there was an agreement which came into the place between both the parties where Tuesdays our Hindu brothers will do their puja at the same place, and on the Fridays, our Muslim brothers will be allowed to offer their namaz. The fact of the matter, even in the place there, even the Hazi did mention that there has been a peaceful atmosphere. Unfortunately, there has been a bone of discontention here between the two communities. I would say Supreme Court is supreme and it shall definitely bring justice. Like we saw in earlier cases, this too shall come through. But the fact of the matter, we need to understand now, let us have a peaceful environment. Let us come to agreeable terms.
Well, I know for a fact that this is a bone of contention. I'm not sure of bone of discontention, but I can also tell you very clearly, Syed Asad Abbas, that the arguments, if you have paid attention to any of the arguments that have been made in the past cases of such disputes, is that the argument has always been that Places of Worship Act does not apply to those places which are under the ASI Act. That has been an argument that has repeatedly been made.
But there have also been several cases, Madhav Saab, where even the ASI has been challenged. Like even in this case, the petitioner in charge has even disagreed on multiple points with the ASI. So
of
therefore,
course, you can disagree and challenge any body. There is nothing is beyond the law. Of course, ultimately law is supreme. But let me take that across to Anurag Naidu. Anurag Naidu, would you like to respond to Abbas, who says that what happens to the Places of Worship Act and what is its relevance if this kind of order can be given? Please respond to him.
Yeah, thank you for having me on the show, Madhav. Am I audible, Madhav?
Yes, please go ahead.
Madhav, see, look, in this particular case, Madhav, this is, again, law of the land can be twisted, can be interpreted the way we want. But look at this particular case. Bhojshala is viewed not merely as a temple, Madhav, but it's an ancient seat of Sanskrit learning and civilizational heritage. Now, whether that can be challenged, no, that's claim from one side. Now, this makes this issue very emotional and cultural, not just religious. Now, if you see how courts have, this particular case, the High Court of Madhya Pradesh has dealt in a very, very objective manner, where the ASI was asked to do a very thorough and a lengthy survey. It runs into multiple years. It's not just about a couple of weeks or days. Now, after the findings are put out, the judgment is given. Now, this is something that we must appreciate. This is about history and heritage, not hostility towards any particular community. Today, nobody is responsible, and any solution should preserve peace, dignity and communal harmony. Courts and evidence has to be on the top and not any anger. Now this should be our guiding principles and decisions, and we must respect for all faiths and lawful coexistence, and that should be the central point. Now it is not about one side winning or one side losing. It's about what is the fact, and that fact we all as Indians should respect and should responsibly hold up with a high dignity and support each other.
Sarfaraz Wani, respond to that. At the end of the day, if we are a society where there is rule of law, we have to respect what the courts say. Sure, I mean, there have been no, violent protests or anything of that sort, but ultimately everyone has a right to approach the Supreme Court as well. Notwithstanding that, at the end of the day, what's being stated by Anurag Naidu is that you have to go by, at least for the moment, in the absence of any other adverse order, what the High Court has said, and that has to be accepted by all. Do you agree with him?
See, Madhav, medieval history is much more complex than we think. It's not a masjid has been built and mandir has been demolished. There is a broader perspective of what medieval history is all about. Number first, Madhav, the Places of Worship Act was brought in only with this purpose.
No. First explain the point you made on medieval history.
Let me make my first.
No, please, because what you're saying is directly opposing what the High Court has said. So please explain your point.
I'm not saying
Before
that.
We get into Places of Worship Act, you're saying it's more complex, temple not destroyed, mosque not built over it. What do you mean by that?
The only reason, see, every statue has a reason to be brought in. The only reason of bringing this statue was to stop this debate of masjid built over a mosque or something. So the only purpose was, at some point we want to finish this, and from here onwards there would be no masjid mosque debate in the country. First of all, the whole purpose of the act has been overridden by the courts. Number second, Madhavan, the Archaeological Survey of India gives only a report. It doesn't give a finding. and how to interpret the report, it's for the courts. So we can definitely challenge what the courts have said, and the courts do change their opinions on certain things with time. In Babri Masjid case, the courts relied on ASI.
Please tell me, what is a report without a finding? Please explain to me, Mr. Vani. What is a report without a finding? You know, you are speaking in riddles today. You say that medieval history is complex, you refuse to accept that. What is the, we refuse to justify that. You say that they give a report and the report does not have findings. Then what will the court act upon? And why do we have reports then if they have no findings?
My point is the report which the ASI gives is not binding on the court.
Of course, it's not binding, but they will give their interpretation, their opinion.
Is for the court to decide.
So it is their finding. Don't say that there are no findings. Come on.
Broader legal principle of prescription also.
And have you? I hope you have gone through what the High Court has said today.
Let me complete my point.
No, have you gone through what the High Court has said today?
I have read the judgment. My point is the broader question of prescription has not been looked by the High Court, because there was a Kamal Mustafa mosque there where the Muslims were worshipping for centuries.
Yes, so and they have actually asked. They have actually asked if they want, there can be a separate place of worship for Muslims. A separate land can be sought. But let me quickly bring in one by one. All right, there's a breaking update coming in. In fact, before I come across to other panelists, a caveat has been filed before Supreme Court by Jitendra Singh Vishen. The Hindu side litigant is also a petitioner before the Madhya Pradesh High Court. It has been prayed in the caveat that he shall be heard by the Supreme Court before passing any order in the Dhar Bhojshala case. So very significant there, Subrashta. Even before the petitioner has reached, a caveat has now been filed. But please respond to Sarfaraz Vani, Subrashta.
Sarfaraz Vani made an argument where he did not really, expand on it by saying that medieval history had certain things. Let's not go into that. I would want to go into that. Because Madhav, the root of the contention is right there. Till the time in this country there is a durable and secular reconciliation over contested sacred sites, I don't think we can have this conversation properly that, deals with the emotional side of things. We can deal with things constitutionally and legally. After all, Ayodhya, the temple at Ayodhya has been built. Ram Lala Virajman has happened, and it was fought, it was a very peaceful battle of ideas and battle of histories that we saw unfold. My problem is, why can we not... No, Sarfaraz Vani, I did not interrupt when you were speaking. I would want the same courtesy to be extended to me.
Let's not speak over each other. Mr. Sarfaraz Vani, one by one.
You are a lawyer of this land, please.
Yeah, let's go one by one because we're just eating up into the debating time of each other. Let's not do that.
There has to be honesty about history. There has to be civilizational empathy. And there has to be voluntary gestures of accommodation, without which this burden should not be framed as a collective guilt of present-day communities and medieval actions, etc., etc. It should be a shared willingness to acknowledge that certain historical wounds have been put on the body politic of this nation, on the spiritual and religious fabric of this nation, and the onus of proof lies on the Muslim community. And I'm being
Sarfaraz Vani. All right, you made your point. Now, Sarfaraz Vani, I want him to respond to you, please.
See, Madhav, saying it was peaceful will be injustice to all the people who were killed. Even Supreme Court in its judgment recognized that Babri Masjid was illegally demolished. So the process by which the temple was made in Ayodhya was not at all peaceful. In history, there has been demolition of it. But the court did
to the Supreme Court again.
Why did the Supreme Court allow the construction,
something else? But Supreme Court recognized that Babri was illegally demolished. Supreme Court recognized this in its own judgment. Supreme Court said that Babri was illegally demolished, even though the verdict came in favor of a group. But Babri being illegally demolished has been recognized by the courts also.
One by one. Yes, but the court has ultimately allowed for the construction of that temple. Ultimately, one second. Ultimately, let's just remember one thing, that whatever is happening right now, whether it's the High Court, whether it's the other cases, if there is an appeal in the Supreme Court, it will go in for that appeal and then that matter will be heard legally speaking. So let's not second guess what the courts will do for the moment. We can have our differences of opinion, but ultimately the only way to settle this in any country where there's rule of law is to go through the courts, and one has to respect to that extent what Anurag Naidu said, whatever the courts say. Anurag Naidu, Subrashta, Sarfaraz Vani, Saeed Abbas, I'd like to thank all of you for joining us this evening.